And good morning to everyone. On behalf of the Denton's Think Tank on Infrastructure and Strategic Innovation, I would like to welcome everyone to today's roundtable. The government leadership and public policy pillar of our think tank, in collaboration with the Keystone Policy Center, is co-hosting today's virtual roundtable discussing the most significant decisions of the latest Supreme Court term, particularly the impact of the Slaughter decision on independent federal agency decision making. Our think tank, the Denton's Infrastructure Think Tank, has almost 800 members and 18 pillars of focus. We host monthly virtual roundtables on a variety of key topics. Membership in our think tank is free, and we encourage you to join us as a panelist at one of our roundtables, a contributor to our content, or as a regular part of our audience. And I want to give a special thank you to the Keystone Policy Center for co-hosting today's roundtable and introduce Christine Scanlon, President and CEO of Keystone, to make some opening remarks.
Well, Linda, thank you so much. I really appreciate those kind remarks. And what an amazing conversation we're going to have today, and so timely. This is quite an esteemed, brilliant group of people, as always, assembled by Dentons and Clint. And we're honored to be a part of these conversations. And I'm really looking forward to both the discussion and the thinking that's behind these conversations that are pulled together. It's always something that I take very seriously here at Keystone, and the takeaways from these are both important, timely, and really spur a lot of critical thinking on our end. So really appreciate the time.
Thank you, Christine, as always, and welcome everyone. My name's Clint Vince, and I chair Denton's U.S. Energy Practice and also co-chair our global transportation and infrastructure sector. And together with my teammate, Emma Hand, we co-chair this think tank. I'm honored to host today's conversation with three really exceptional guests. As Linda mentioned, our topic is the Trump v. Slaughter decision at the Supreme Court and its impact on independent agencies and ultimately on infrastructure, investment decisions, and social policy. Our first guest today is Amy Howe, and Amy's the co-founder of SCOTUS Blog, which is a news site devoted exclusively to analysis of the U.S. Supreme Court. Amy's part of a blog team that won a Peabody Award in 2013, and she also won a National Press Club Journalism Award for breaking news. Amy served as the Supreme Court analyst for the PBS NewsHour, and before turning to full-time journalism, Amy served as a lawyer in more than 24 cases at the Supreme Court. Amy has taught courses on Supreme Court litigation at Vanderbilt Law School and also Stanford and Harvard Law Schools. Our second guest is my law partner and friend, Simon Steele. Simon splits his time between our litigation practice, our energy practice, and our federal regulatory practice. And Simon is a former U.S. Supreme Court clerk and an expert on federal appellate matters, and my go-to guy whenever we have a complex case at the Court of Appeals or up to the Supreme Court. Our third guest is another distinguished partner and friend at Denton's, and that is Sam Olens. Sam is in our federal regulatory practice and is also a member of our firm's state attorneys general group. Sam's a former twice elected attorney general from the state of Georgia, and he also served as vice president of the National Association of Attorneys General. And Sam's also served in a number of significant positions in civil society, and I have quipped with him that he's one too many awards for us to be able to mention it during this hour that we'll have going forward. This is really a perfect team to discuss the importance of the Slaughter decision, and which I think we all believe is one of the more consequential decisions of the Supreme Court. We do have a Q&A feature for this fireside chat, and if you do have questions, please feel free to put them into the Q&A platform. Please do not put it into the chat, or you will make me dizzy trying to go between the chat and the Q&A feature. So with that, let's just kind of launch into it. And Amy, if we can start with you, if you could just give us a quick overview of the Slaughter decision, and then, rank it in terms of importance from your perspective.
I'd be delighted to do that. And thanks so much for having me. It's great to be here. So Trump versus Slaughter is the challenge by Rebecca Slaughter, one of the Democratic commissioners on the FTC, to Donald Trump's firing of her. In an email, there are 5 commissioners on the FTC. Under federal law, no more than 3 can be from any one political party. They serve staggered 7-year terms. They are appointed by the president and confirmed by the Senate. Under federal law, at least up until last month, they could only be removed by the president for inefficiency, neglect of duty, or malfeasance in office. But when Trump sent Rebecca Slaughter an email firing her, he said only that her remaining in office was inconsistent with his administration's priorities, and he was relying on his power under Article 2 of the Constitution. She went to court to challenge her firing. The U.S. District Court for the District of Columbia ordered the Trump administration to reinstate her. The D.C. Circuit upheld that ruling, pointing to a 1935 case called Humphrey's Executor, in which the Supreme Court had rejected a challenge to the exact same law governing the FTC, a challenge that relied on the idea that it violated the separation of powers. So the Trump administration came to the Supreme Court asking them to pause the district court's order. And U.S. Solicitor General John Sauer pointed to earlier rulings by the Trump administration on its emergency docket involving members of the National Labor Relations Board and the Merit Systems Protection Board, involving similar statutes in which the Supreme Court had allowed the Trump administration to file members of those independent agencies, and said this case is indistinguishable. The Supreme Court agreed to take up the case and put the orders on hold, effectively allowing the administration to fire Rebecca Slaughter while the litigation continued. The court heard oral arguments and then issued its decision, at the very end of the term before its summer recess, and by a vote of 6-3, reversed the lower court ruling, said that the statute that only allows the president to fire in cases of inefficiency, neglect of duty, malfeasance in office violates the separation of powers. It was an endorsement of what's known as the unitary executive theory. The decision was by Chief Justice John Roberts. He said that the Constitution gives the president the executive power, and as part of his duty to carry out the laws, he needs to be able to fire the officials who might stand in the way of his ability to do that. The 3 liberal justices dissented in a decision by Justice Sonia Sotomayor. So in terms of ranking the decisions, there was a lot of competition this term. We had the tariffs decision. We had, Louisiana versus Calais. We had transgender athletes. We had the birthright citizenship case. But I would say that this one is potentially the most important because of its, possibly far-reaching effect on how independent agencies operate. If you talk about the tariffs case, certainly it was one of the president's top priorities. He has been fixated on tariffs for a long time. But once the decision striking down those particular tariffs was issued, he was able to resort to other laws allowing him to impose tariffs, even if logistically and sort of structurally it might be more difficult than the tariffs that he imposed under the International Emergency Economic Powers Act. And in terms of the Birthright Citizenship Act case, obviously that case would have been monumentally important if it had gone the other way, and it was much closer than many of us who watch the court on a regular basis expected it to be. But in the end, the court preserved the status quo. So, for I think many of the reasons that we're going to spend the next 45 minutes or so discussing, I think that Slaughter has the potential, likely was the most important case, because of its potential effect, because of its full-throated endorsement of the unitary executive theory.
That's really a great job of boiling down an incredibly complicated decision in an understandable way. Is it fair to say now that so-called independent agencies are no longer independent?
I mean, I think there's going to be some perhaps litigation around the margins about, obviously we can talk a little bit about the special carve out for the Fed. And one of the really fascinating things about the day that the court issued the decision in the Slaughter case, it issued the decision in the Cook case. The Chief Justice wrote both of them. If you were sitting in the courtroom listening to the Chief Justice read his summaries, you would hear him issue his summary of the Slaughter case and find out what happened in that. And it was probably another 20 minutes or half an hour before you found out what happened in the Cook case. But those of us who were down in the Supreme Court's press room, where they hand out paper copies of the decision as they're being announced in the courtroom, we literally got the two decisions banded together. And what some of my colleagues in the press room were saying that the court may not have wanted the markets to sort of worry even for a moment about what was happening to the Fed. And the court sort of left open the possibility that there could be other agencies like the Fed that might qualify for some sort of carve out, but we're not really sure what those are.
What does it signify that only two justices, Chief Justice Roberts and Justice Kavanaugh, were in the majority in both Trump v. Slaughter and Trump v. Cook?
I mean, I think you can think about it on a couple of different levels. I mean, just from a sort of a purely statistical matter, like that is the center of the court. They were in the majority in all cases, the Chief Justice and Justice Kavanaugh, 95% of the time last term, the term that just ended, 92% of the time in cases that were divided. So, they are sort of where the action is. I think on a sort of so if you sort of take a step back, you have almost sort of a Venn diagram where you have sort of the justices to the right of those justices are sort of the full-throated unitary executive theory. Why would we have a carve out for the Fed necessarily? And then on the left, you have literally the Democratic appointees who voted with the chief and Justice Kavanaugh in the Cook case. And Justice Barrett in one of the things that was fascinating about the Cook case was that it didn't address the Slaughter case at all to sort of differentiate them. And in her dissent in the Cook case, Justice Barrett said, there's a serious tension between Cook and Slaughter, and the Chief Justice didn't even bother to respond to them. So there's the sort of the Venn diagram, and those are the two justices again that are in the middle.
Thank you, Amy. I'll come back to you in a minute, but I'd like to include our other guests now. And Simon, what is your view on the importance of the Slaughter case? And also, can you give us a little bit of background on what the contextual history is regarding independent agencies leading up to this Slaughter case? And I know we're co-authoring an article for Public Utilities Fortnightly shortly, and I know you've covered it in a draft that I saw that looks really, really interesting.
Thanks, Clint. So I'll second everything Amy said and sort of raise the stakes even further, maybe. In my mind, Slaughter is, at least in the realms of administrative and regulatory law, the most important decision so far of the 21st century, and I don't think it's close. I think it's significantly more important than Loper Bright, the case that reversed the Chevron doctrine on statutory interpretation that was decided 2 years ago. Here's a little bit of why I think it's so important. Again, Amy touched on the fact that while obviously the Supreme Court decides the case before it, and the case before it was about the FTC, it is very clear that the Slaughter decision extends by its logic and in light of the other shadow docket cases Amy mentioned to other agencies. Beginning in 1887, 140 years ago, with the Interstate Commerce Act, Congress created the model that Amy outlined of administrative agencies. Multiple commissioners, staggered terms, typically 5 members, protections against conflict of interest and separate employment, and importantly, a partisan mix, no more than 3 members from one party. That model was designed very consciously to do a couple of things. One is it effectively, at least on the most of these statutes, gives the president the power to appoint the chair of the commission. And in practice, it means that the president's party will have appointed 3 of the 5 commissioners. So it creates a degree of presidential control. At the same time, it created independence. We admin law geeks have learned for 50 years that these things are called independent agencies, which you rightly say they're no longer called now. That model was upheld by a 9-0 vote by a very eminent Supreme Court, including Oliver Wendell Holmes and Louis Brandeis, in 1935 in Humphrey's Executor. It was essentially re-upheld with slightly different reasoning in Morrison v. Olson, the independent counsel case, by, again, a court that was unanimous in that regard in 1988. And in the interim, Congress used that model to create the FCC, FERC, the FEC, the NRC, the STB, the SEC, you name it, basically all of the major regulatory agencies that exist. Congress relied on that model when it wrote the Administrative Procedure Act, which are designed for agencies like that. And Congress relied on that model when it felt like it had created independent expert agencies, and therefore those would be a good place to put some adjudicatory power as well as executive power, since they'd be somewhat insulated from political influence. I don't think Slaughter entirely destroys that model. It doesn't say that every aspect of those statutes is invalid. The FTC still exists. None of the FTC's decisions are going to be reversed. The FTC still has staggered terms. An agency like FERC still has a provision that says it can only act with a quorum of 3 commissioners. But getting rid of the limitations on the president's power of removal, getting rid of the full cause requirement and making removal at will has profound effects, because it means that, for example, in precisely the Slaughter case, the president got rid of the Democratic commissions. He didn't pretend that was a coincidence. Likewise, an agency like FERC, there's 3 Republicans, 2 Democrats. The president could just now get rid of the 2 Democrats tomorrow. The president can also just essentially neuter agencies. The president, since Slaughter, has just fired again at will all the commissioners of the Election Assistance Commission. So that makes President Trump the most powerful president in the history of the United States. By multiple measures, the power of the federal government's expanded in part because Congress was comfortable reposing a bunch of that power in independent agencies, which are no longer independent. President Trump can now just fire commissioners at will and therefore prevent commissions from having their quorum that they need to act. And he can get rid of all the Democratic commissions if he likes. There's a lot of questions after Slaughter, and it has very broad rhetoric about the unitary executive theory, but it is specifically a decision about the removal power. So, as I said, there's other aspects of those statutes that haven't disappeared. Commissioners can still only be appointed with the advice and consent of the Senate. That's clear on the face of the Constitution. And there's a lot of questions about how far the Slaughter decision reaches down, or really how far the court might reach down in future decisions, which the Trump administration is aggressively calling for with respect to whether the president can fire administrative law judges at will, immigration judges at will. That's a case called Jackler that's before the Federal Circuit, which is the number one case that I'm looking at as sort of the next pin to drop in one direction or the other. And I'm not sure how far the court will ultimately go. But the president does have this unprecedentedly broad power of removal at will for multi-member agency commissioners. And with the power of removal necessarily comes the power to threaten them explicitly or implicitly. They'll have clear messages that if they don't pursue the president's agenda and if they rule on cases in a manner that he doesn't like, they could be fired.
Simon, to your point on giving the specific example of the Federal Energy Regulatory Commission, a bipartisan group of 11 commissioners, including 7 former chairs, filed an amicus brief, an unusual brief, before the Supreme Court with respect to the Slaughter decision, urging not to overturn the Humphreys executor decision. And their concerns were that this could cause FERC to become a very partisan agency, that its positions could flip every election cycle. And also they were concerned about longer range implications for energy companies plus consumers and also their investors because of the long-term nature of this type of infrastructure investment. I think when you and I spoke, you were going to undertake a reading of that amicus brief. Did you have a chance to do that?
Yeah, it's a terrific brief, and along with maybe Justice Gorsuch's concurrence, if someone were to read 20 pages and didn't have time for more, those are probably the 2 things I would most recommend from the Slaughter docket. As you said, it is a truly bipartisan brief. A broad cross section of FERC commissioners over the past 20 years or so, and they make some very important points. First, let's think of it in the context of Cook, right? Cook, the Federal Reserve case. There are probably 2 main reasons why Cook ends up coming out different from Slaughter. One is, and this gets very geeky, there's some deep history about the first Bank of the United States and the second Bank of the United States. And was this a model for it? Banks are kind of different. And there's also some public-private mix aspects that make the Federal Reserve kind of a unique institution. Then there's the pragmatic aspect of why Cook is different and why I think most people expected Cook to be different, and why the US Chamber of Commerce argued in favor of presidential removal power in Slaughter, but against presidential removal power in Cook, which is, geez, markets need confidence in stability, and especially in something as important as the Fed. And if you blow that up and say the president can willy-nilly just control the Fed, then that could have, as Amy said, caused a sudden run on the market. The FERC commissioners in their brief said, okay, FERC's not the Fed, but it's pretty important. FERC's rate-making function dictates, in effect, the value of investments in energy infrastructure every year that amount to something like $40 billion. Those energy investments are long-term investments. They're huge investments. The nation's prosperity and energy security depends on those investments. And if industry can't trust that it knows what regulatory rules and approaches are going to be used to those, if rate-making principles are just going to be changed administration by administration, if fossil fuel industries are going to do great under a Republican administration and terrible under a Democratic administration, and vice versa for alternative energies, then that is going to destroy a lot of business confidence and potentially a lot of investment. The FERC commissioners also argued, and this harkens right back to the legislative history of the 1887 ICC Act. Congress then was pretty prescient, that a 5-member bipartisan commission with some insulation, but not complete insulation from political forces, tends to give you the benefit of expertise. Those staggered terms and those multi-year tenders give you the benefit of experience. You get the benefit of dissents, especially on something partisan, which brings transparency to the fore. You just get less sudden transitions. You probably get better agency morale as well when you know there's continuity. As someone who has spent quite a bit of my time over the past few years practicing immigration law, I can tell you that while FERC decisions vary a little bit as to how different ALJs and different FERC commissioners will come out on rate making, that is absolutely nothing compared to the massive seesaw and wholesale reversal of precedents that you get when administrations change with respect to the immigration courts, and particularly under the Trump administration, given the clear and long established lack of any independence for immigration courts.
Thank you, Simon. I'm going to turn to Sam in a moment, but 2 quick comments. One is that Simon's immigration cases are all pro bono cases, helping people that are in distress and cannot protect themselves. And also, with respect to FERC, a personal comment. I've practiced before FERC, before all of the 11 commissioners and chairs that submitted their amicus brief. And I must say, my experience has been, regardless of party, that the FERC commissioners have really almost always tried hard to work together. Not always, every once in a while, some partisanship would creep in, but not very often. And the FERC decision-making has been regarded as extremely stable because of that. The decisions are not reversed every 4 years. And I am deeply concerned about the warning that the 11 commissioners gave to us, because I think it will impact long-term investment in energy, infrastructure, and beyond with all of the other agencies that also impact infrastructure decisions, especially very capital intensive long-term infrastructure investments. Sam, what is your take from the perspective of a former Attorney General on the Slaughter decision? How consequential is it, and what other reflections do you have?
Thank you. First, it's a pleasure to be with you today. Three general points that I want to make. Number one, both Slaughter and Cook continue an exercise of too many cases being handled through the shadow docket. We now have more and more of these significant matters coming before the Supreme Court post haste, without really providing the courts below a full opportunity to hear the cases. And many of these cases are not emergency matters. They're not matters that needed to go through the shadow docket. Secondly, it is hard to keep a total straight face to distinguish Slaughter and Cook. At times, I think the discussion is more about the effect of business confidence than strict adherence to the law. And by definition, when terms such as inefficiency, neglect of duty, or malfeasance are wiped out, I think that's dangerous to the court, dangerous to our rule of law. And I think the third point here is that we have a president who seeks to have much more power than the normal president, and the Supreme Court is encouraging and engaging in that additional power. So if you're President Trump and your folks are looking at the Slaughter decision, you're immediately thinking, what's your next three steps to go even further than you thought you could before? So I think when you look at this session, but for some cases that were glaringly weak by the administration, such as the tariff case and the birthright citizenship case, he's got to be smiling at these decisions that are flowing from this Supreme Court. And I think it bodes poorly for years to come, because Slaughter will be quoted over and over again. And I'm reminded of the idiom about what's good for the goose is good for the gander. Whoever the next president is going to take full advantage of this Slaughter decision also. So I think it bodes poorly. Congress is no longer as important. Agencies are no longer as important. You link this to Loper Bright, and we're having, for the first time in decades, a very strong Article II executive branch, thanks to our Supreme Court.
Thank you, Sam. This is a bipartisan panel. I was anxious to get your perspective on this as a twice elected Republican AG, and I don't disagree with anything you've said. We generally try to keep our discussions non-ideological, and I have to commend Amy and Simon for doing just that, and I appreciate your comments as well, Sam, and your candor. It's been mentioned, I think, briefly, that the Election Assistance Commission, just, I think, a week after the Slaughter decision, was effectively dismantled. What is your take on that?
Well, I mean, the president's taking advantage of the decisions that have been given to him. By definition, he has greater ability to remove people. And of course, that's going to make, frankly, members of both parties nervous about the midterm elections. I don't see these issues as partisan one way or the other, because, once again, the goose and the gander, it's going to come the other way. I think the EEC firings are similar to numerous other agencies Simon alluded to, that historically have stayed above the partisan fray that quite possibly may not have that same ability.
What do you think this portends for the Endangered Species Act and comparable
So I think you
legislation?
need to look at that in light of Loper Bright. And in light of Loper Bright, he's going, okay, I now have an opening to say that the statute and the prior rule are not consistent, and I'm going to enact a rule that I think is more consistent with the statute. Clearly, the environmental community will promptly file suit when the rule is finalized. But I think the administration has to feel that the combination of Loper Bright and Slaughter have enhanced their opportunity there.
Um, what percentage of Americans do you think have any idea what has just occurred in Slaughter?
Two?
That's my concern as well.
This is inside baseball.
I
What
mean, I think the
impact?
better question is like what percentage of Americans could tell you, could name all 9 justices or tell you who the Chief Justice is.
We need you three more than ever. Sam, what do you think the impact on this decision will have in terms of long-term investment in capital-intensive infrastructure projects?
That's a difficult question, Clint. I think that one would like to say that it won't have much effect, but when you look at what the administration's done on wind power and the effect that has had and the time it's taken in our courts, both the wins and losses, I think as it relates to the climate issue, you do have to take a step back because subsequent litigation and the years of appeals are now part of the financial consideration.
Thank you, Sam. Let's go back to Amy. And what do you expect further development on this topic of presidential removal in the next term?
I think that seems likely. I'm not sure exactly where it's going to happen, but I think, certainly when you look at the Slaughter decision and the Chief Justice in his opinion, talks about, okay, well, we've got agencies like the FTC, and here are the officials not before us. And so, you've, as I think Simon and Sam have talked about, what is the president's power to fire members of the civil service? If he's got the authority to fire, the Senate confirmed officials, why wouldn't he have the authority to fire individual government employees? We've got the carve out for the Fed. Is there anything like the Fed, we're not we haven't said anything about the tax court or the Court of Federal Claims. We leave those questions for another day. And so, to a certain extent, he's writing a roadmap for some of the future litigation in all likelihood. What does
Thank
it mean
you.
to fall within the president's general administrative control is going to be, I guess, the next fight in all likelihood.
Yeah. Amy, is there anything that we haven't covered in this Q&A that you would like to focus on before I move on to Simon?
I do think, and Simon touched on it, I think it's really interesting. On the one hand, Justice Sotomayor in her dissent talks about the prospect of chaos. And, you always have the dissent as sort of the doom and gloom of any decision. Justice Gorsuch joins the Chief Justice's opinion on the one hand, but on the other hand, has this separate concurring opinion in which he is apprehensive or expresses apprehension about giving the president all of this control and, says, well, Congress has created this one-way ratchet where to take the power back, and this was something he talked about at the oral argument, to take the power back from the president Congress is going to not only have to pass legislation, but it's going to need a veto-proof majority, because what president is going to want to give the power back to Congress? And so he, says it's really up to the courts to act. And so I guess we will see whether, whether or not the rest of the justices are willing to do that.
Thank you, Amy. Simon, do you think there's going to be further development in the next term on the subject of presidential removal power? You talked a little bit. Maybe you can go into more depth on the possibility of going beneath the agency heads and commissioners to law judges and also non-appointed members of the agencies.
Right. I think the probability of a follow-up Supreme Court case on this in the next 2 years is close to 100%. I'm not so sure about the very next term. Using Amy's wonderful resource, SCOTUS blog, I looked up all the cases that are pending and likely to be decided next term on the merits docket. And there's nothing really on point quite yet, and it'll take time, obviously, for these cases to filter through the courts. Some of the most important cases are actually before the Merit Systems Protection Board, and then they'll go to the Federal Circuit and then potentially to the Supreme Court. That said, Sam mentioned the shadow docket. It's very possible there could be stay applications, so things will hit in the next term. There, among pending litigation that I'm aware of, there's the Jackler case before the Federal Circuit I mentioned before about the firing of immigration judges. President Trump came in and got rid of basically every immigration judge who was either a Democrat or too inclined to grant asylum in his view. And just completely remade the agency, obviously on an at-will basis. That's a different issue from independent agencies, because of course the Executive Office of Immigration Review has never been an independent agency, but it's still about whether there is complete presidential power and whether Congress can restrict that power, as Congress did or purported to do with respect to immigration judges. There are other cases before the MSPB. I think one involves Lozoya, the former pardon attorney, and another involves the former U.S. bankruptcy trustee that may well go higher up. There was a case called Lemelson about SEC ALJs, although I think that's going nowhere, because one thing about these cases and why they don't come up that much is that various private litigants, like folks subject to enforcement at the SEC, have tried to raise arguments saying, this person's appointed under, this ALJ is appointed under an unconstitutional statute under which they can't be directly removed by the president. And in those cases, the court has been pretty consistent that the statute's severable and it doesn't create standing for someone to say, aha, I was essentially convicted by someone with a defective appointment. All these unitary executive cases do is say that if and when the president wants to remove someone, he can remove them. They don't retroactively make the whole agency and everything it's done invalid. That would be insane chaos. The Trump administration has also, by regulation and in some MSPB proceedings, sought to take away civil service protections. And this is getting into the issue of how low can you go. You clearly, the court is clear that heads of agencies, including, for commissioners, are subject to complete presidential control with respect to removal. There's also a long-standing and clear line of precedent that says that if you're a really low-level employee, government employee or government contractor without any policy-making functions or executive authority, you can't just be fired because you're a Republican or a Democrat. There are these anti-patronage First Amendment cases, but how high up those go in terms of the rank, at what point someone is an inferior officer with executive power such that they have some sort of removal protection, precisely what removal protection that is. These are questions that have been percolating out there under the unitary executive theory rubric for quite a while. One reason I think why Slaughter hasn't created the headlines that we all think it should do is it didn't come out of nothing. For 16 years, the Roberts Court has been doing various cases about the PCAOB and the CFPC and the FHFA and so on, some of these lesser known agencies in which it has to some extent tackled some of these inferior officer issues, but both how low you can go and how much Slaughter applies to adjudicatory as opposed to executive functions. If you can actually find someone who has purely adjudicatory functions like an ALJ or an ILJ, those I think are the big questions that we're going to see. We're also going to see whistleblower cases. Here's another hypothetical, which I think is really interesting. Assume that Democrats take the House of Representatives in November. Assume there's then a lot of congressional hearings into how various agencies have conducted themselves under the Trump administration. Assume that Congress calls upon all of the commissioners of those agencies to testify before it, to write reports, et cetera, et cetera. The president says, I have unitary executive power. I forbid you from testifying before Congress. I forbid you from sharing these agency documents with Congress. If you do so, I will exercise the removal power given to me in Slaughter, and I will fire you. Slaughter says the president has completely at-will removal power. But might there be an exception for that or a limitation to that in the context of the separation of powers if the president is interfering with Congress's ability to obtain information? Those are the sort of issues that I think may well arise, and I think we're all obviously very confident that the Trump administration has taken really extreme and unprecedented positions on all of these issues. One of them, probably the most interesting aspect of the Cook decision to me is footnote 2. The Trump administration argued that regardless of the merits of whether Cook could be fired, the court didn't even have jurisdiction to address that. That is how extreme a position this administration is taking, and I was, heartened to see that the court at least rejected that.
Very close decision. Sam, what are your reflections on these points? You just need to come off mute, Sam.
I'm sorry. So 2 points. One, where Simon was, where I thought we were going to go was, the Democrats, if they take the House, can seek to have a whole bunch of hearings, but it's not like the Justice Department is going to act if they decline to attend. So there are some limitations, and the president's had a liberal pardon policy. Second, this unitary issue is very much limited to the federal government. Most states do not have a unitary system. In fact, for instance, as it relates to attorneys general, there's only about 7 states where the governor appoints the attorney general. They are predominantly elected. And in fact, in many states, you could even have a governor and a lieutenant governor of different parties. They don't necessarily run together. Many states have already passed bills that limit the effect of slaughter on the federal level. Now, so I think that limits the effect of slaughter. If someone's thinking, well, how's this going to relate to states? It's not going to relate to states very much at all.
I think that's a critically important point. One member of our team raised the question of whether there would be an impact or whether there would be a predictive impact on states. I think she was looking at it possibly more from the standpoint, would governors begin to emulate the position of the current president? But I think your point is very important for our audience to ponder and think about, and we'll see how things develop. Is there anything else, Sam, that we haven't covered that you would like to weigh in on with respect to slaughter? And then in a moment, we'll go to a lightning round and actually start with you and go in reverse order.
So, look, a year ago, we wouldn't have known that Slaughter and Cook would have come forward, or maybe 18 months ago, for sure. So, going back to the comments by Amy and Simon, clearly within 2 years, I think you have to anticipate several significant cases coming before the Supreme Court. May not be next year, but clearly within 2 years. And that's when we're going to see a lot more of what this decision means on the margins.
Thank you. And Sam, why don't you start us off with a lightning round, just a minute or so of the most important point or points you'd like to convey today.
I think the most salient point is that the conservative wing of the Supreme Court is providing the president much opportunity to hold immense power. And I think for many folks in the other party, they should take a deep breath because they're going to be the beneficiaries at a later date. So at times when we talk about, separation of powers and which has more power, I think due to these decisions, there's going to be a really strong argument that it's the executive branch nowadays.
I would have to agree with you. Simon, what's your perspective?
I thoroughly agree with Sam. Random historical note. Back when Chief Justice Roberts was going through his nomination hearings, there was a huge focus on the unitary executive theory because he and other lawyers in the Reagan administration had sort of pushed it before they became judges. And in the course of those hearings, I remember there was a remark by then Senator Biden, who sort of jokingly said, I'm kind of torn on this. Maybe I might be president one day. So there's for precedence. I do think that the one thing we ought to do, since we're a multi-member commission here, is disagree on something. So I'll raise a little bit of a query about what Sam said about Loper Bright. I was one of many people who wrote stuff criticizing Loper Bright a couple of years ago. I'm a Democrat. I'm not a fan of President Trump. I think I'm now a fan of Loper Bright because now that every agency is controlled by the president and controlled by President Trump's policies, I'm pretty happy that Loper Bright says that the courts are going to decide what the law is, not the agencies. When the agencies mean President Trump, it actually becomes a limitation on presidential power at this point.
I think that coincides with Sam's what's good for the goose is good for the gander comment, which is one of my major takeaways from this discussion. Amy, would you like to finish with a big exclamation point? And you also need to come.
Yep,
There you go.
thank you. I too am going to echo, in particular, Sam's point. That was sort of the theme in my end of term wrap up, was that the president did lose a couple of his biggest priorities, birthright citizenship and tariffs, but those were really the cases in which he was swinging, I like to say, not just for the fences, but for the parking lot. He won, and cases like Slaughter, and really got an enormous amount of executive power. And then, a bigger picture, I guess we really do have a multi uh, all views. I am a registered independent as a journalist. We have like you sort of joked a little bit about how much people know about the court. Whether you like this court or not, there are a variety of different views on it, but we have this particular Supreme Court because the Republican Party for so long made the Supreme Court a priority. That was primarily because of abortion, but you know, Donald Trump got elected in 2016 in no small part because he released a list of judges, and that reassured a lot of people that they were ready to vote for him. And Democrats have come late to the idea that the Supreme Court is really, really important in our everyday lives, even if in cases like Slaughter, the people may not recognize that right away.
It's a great point to finish on. Christine, can you bring this panel over to the Keystone Policy Center and invite them to do a talk? This has been so vitally important.
It's been riveting, honestly, and so timely. And I've run the gamut from this is unbelievable to this. My takeaway, the goose and gander analogy, I'm like, wow, this is going to unfold in some really interesting ways over the next few years. And the implications, Clint, I particularly appreciated the FERC conversation. We work, as Clint knows, he has chaired our energy board in the past, and I think this is a topic ripe for discussion with that group. But honestly, I couldn't take my eyes and ears off the screen. So thank you so much. This has been amazing.
Thank you, Christine. And on behalf of the audience, why don't you and I just give this panel a great ovation?
100%.
Thank you all. Have a wonderful day, and I hope to see you again soon.